The real property question from July of 2007 is a complicated landlord-tenant problem. This hypothetical may be complicated, but it is not terribly difficult. Take a look with me at the call of the question. On what theory could Larry reasonably assert a claim to recover rent from Tanya for March and April, and what defenses could Tanya reasonably assert against Larry's claim for rent? Discuss. Well, we've got one plaintiff and one defendant. The theory of liability, almost certainly, will arise out of a written lease, and the defenses that a tenant can offer for failing to pay rent usually will have something to do with the condition of the premises. So, as usual, we've got to interpret the facts in order to make some sense out of what's going on. So I guess it would help to actually read the fact pattern rather than just study the call of the question. At the top, we meet Larry and Tanya in the very first line. Larry leases to Tanya in writing a 4-room office suite at a rent of $500 a month. The lease commences on July 1, 2006. The lease requires Larry to provide essential services in Tanya's suite. And we find out that the suite is on the 12th floor of a new 20-story office building. So far, so good. Do you see any problems with this lease? No. This is not a problem actually about the lease itself. It's a simple thing. We're not going to worry about any details about offer and acceptance or any fraud. It's a very straightforward deal. But now, look at paragraph 2, and here we see a litany of horror stories, both from the tenant's perspective and from the landlord's perspective. Essential services go wrong over and over again, starting in November. So things go badly in November, things go badly into December, so for more than a month, we've got serious problems in this office building. In paragraph 3, we see on the 12th of December, Tanya orally told Larry she's terminating her lease on February 28. Because of all of these interruptions of service, she can't do her business. All of this makes sense. How are you supposed to do your business close to the top floor of a tall building if you don't even have essential services? Now, she picks February 28 to give herself ample time to find a different office space. Now, what's the problem with this? The problem here is that her notification was an oral notification. Almost certainly it would need to be in writing to be legally effective. Now, I look at all of these facts, given that this tenant was in constant touch with the landlord over all of the problems on the property. Ultimately, I'm sort of willing to let her get away with orally giving notice of the right to terminate. Now, you don't have to agree with that, and plenty of people didn't agree with that conclusion and still did beautifully when this question was presented. Now go to paragraph 4. She, in fact, does move out on the 28th of February, even though after December 12th, there were no further problems with the essential services to her suite. Now go to the next to the last paragraph. Here's a set of facts that we see often in contracts and torts and property questions. We've got a plaintiff who fails to mitigate. The landlord doesn't even try to re-let the space until April. And then he finds someone in just a couple of weeks to occupy the property at the same rent, and life goes on. He then brings a lawsuit to try to recover the $500 for 2 months that the property stood vacant. Well, stop right there. Even if we stipulate for a moment that Tanya is on the hook and that her failure to give written notice is ineffective, how much are the landlord's real damages? I would say $250, because that's half a month's rent, and that's how long it took to re-let this office suite. Then, once again, we get the call of the question. So, we take a step back and we compare this real property landlord-tenant question to others that we have available to review, and this certainly is the easiest of the group. Now, granted, we're going to have to find a home for all of these fairly complicated facts, and it's also granted that although probably most of us are sympathetic to the tenant, not all of us are going to find in favor of the tenant. And as we go through my answer, you're going to see that even I leave myself plenty of wiggle room for the tenant to be found liable. But I also indicate that this tenant may have a claim against the landlord for damages. So turn with me to the outline of issues that I offer for this fact pattern, and let's have a look at it together. Obviously, the landlord's theory of liability is going to arise out of landlord-tenant law and out of a lease. So I focus on the lease briefly, then I turn to Tanya's breach. One could say that her initial statement that she is leaving could be considered a breach, and her failure to pay rent certainly is a breach. Now, as to damages, we discussed them below. The landlord's claiming $1,000 in damages. My conclusion will be that the landlord, in fact, does have a prima facie case under the lease. Now, whether or not he will prevail, with regard to the bottom line, we will answer in part 2. Here, you'll see, basically, all I do is present a laundry list of tenant defenses. The covenant of quiet enjoyment, partial or constructive eviction, and then the warranty of habitability. Now that might make you raise an eyebrow fairly quickly, because the warranty of habitability only applies to residential leases. But I bring it up here just to distinguish it from those other covenants that do apply to business leases. Then I focus on Larry's failure to mitigate his damages, and then, right before the conclusion, I indicate that Tanya may have suffered quantifiable harm as well. And if she can prove it up in a counterclaim, she'd be able to reduce any possible recovery that the landlord would have. So that wraps up a quick consideration of how I set up this answer. Now let's have a look together at the model answer that I provide. And I think you'll see that I do a fairly complete job of weaving the law and the facts together. And up front, I want to remind you that there's plenty of wiggle room for you and for me to present an answer that is somewhat nuanced. Basically, I'm sympathetic to this tenant, but I am not so sympathetic to her as to be blind to the landlord's rights. So take a look at the first section of my answer, and you'll see, once again, I lead with the facts. I'm not just copying the facts up front. I'm explaining who the parties are and what the nature of the claim is. Then we focus on the lease. There isn't very much to say about the lease. It looks like a valid month-to-month lease. The landlord has assumed obligations of providing essential services, and there's nothing in the pattern that suggests there's anything wrong with the lease. Then I turn to the oral termination and then her final failure to pay rent. If we assume for a moment that her oral notification is invalid, she's in breach at the moment she fails to pay the March rent. We look to damages. This is easy because we know what the landlord's prayer for relief is. He wants $500 a month for 2 months, a total of $1,000. And I conclude to part 1 that Larry's claim, his allegation, add up to a valid landlord-tenant theory of liability. Whether or not he wins any money on this theory of liability is contingent on our discussion of Tanya's defenses. So here once again in part 2, I lead off with the facts. I explain that Tanya's argument is she's got a month-to-month tenancy and that her oral notice of termination ought to be deemed valid under the circumstances. And there I go into all of the details about what went wrong. Ultimately, I look at all of this and I say her oral termination should have been deemed valid. Now maybe I'm wrong about that. Certainly plenty of people disagree with me. But I can tell you when this question actually was administered, people did come down on both sides of this issue and did equally well. Now, we turn to my little laundry list of defenses, the covenant of quiet enjoyment, partial and constructive eviction, etc. Here you'll notice that I explain what each of these is. There's plenty of law in this answer, even though, as always, I put the bulk of my time and energy in factual analysis. Notice at the very bottom of this page that I focus on damages that may have been suffered by the tenant. Now, we don't know of any dollar figures that she has suffered as harm, but we look at the situation and we see somebody trying to work out of an office that has significant services denied, like, for example, water and heat in the winter or late fall, and that's enough for us to determine that she may well have suffered damages of her own. And to the extent she can prove them up, any recovery by the landlord will be reduced or eliminated altogether. And I find a home for the numbers that we do have, which are very simple and not complicated at all. My conclusion is in favor of the tenant and against the landlord. But even I acknowledge that the tenant may be liable for at least half of 1 month of unpaid rent, subject to any set-offs in damages that the tenant herself may be able to claim.